attendance was about a minute and 48 seconds.
Oh my gosh.
Not joking.
I remember, I think I was in one of your classes when it was like, you had a where you could also show up, and I would show up and there'd be like 5 people.
That's right.
It was like a big, it was like a big lecture hall.
And
It
you-
was like
and
5
everyone-
people and you're like, hi.
Yeah, and everyone thought, well, this is, I'd rather just merely listen to it than see it.
I've got it running, so.
Oh, it's running?
Yep.
I guess I should be more formal. That's right. So we are, I'm talking about the 11th Amendment, one of those Pequot amendments that everyone knows about. Did you ever, I mean, I know you figured it out by 12 elections, 13, right? Slavery. And there must have been one that came after 10. Or did they just skip and go around? It's an amazing, it is actually an amazing amendment. And only because it's so complicated, truly it is. It leads itself to strange, convoluted puzzles. So I thought I would do the 11th Amendment because it is. When Mr. Boyd asked me to do this, he said, oh, because of these convoluted problems you have, you bring up. And I thought, well, I assume that's what he wanted after a fashion when that happened. So it starts off with, if you ever have, this is an interesting book. If you haven't,
I have my pocket constitution, actually.
good. If you know,
When's
Justice
out?
Ginsburg said, this is no book for someone who hasn't gone to law school. The Article 3, Section 2, Clause 1 gives the subject matter jurisdiction of the United States Supreme Court, correct? Article 3, Section 2, Clause 1. The judicial power shall extend to all cases in law and equity arising under this Constitution and laws of the United States and treaties made or which shall be made under their authority, to all cases affecting ambassadors and other public ministers and consuls, to all cases. Notice all of this is cases, and they're all preceded by all. Right? It's a universal introduction. All cases in admiralty maritime jurisdiction, and then not to all, but just to controversies to which the United States shall be a party, to controversies between 2 or more states, between a state and citizens of another state, between citizens of different states, between citizens of the same states claiming land under grants from different states, and between a state and the citizens thereof of foreign states, citizens, or subjects. So the only thing I can figure out is that cases refer to subject matter and controversies refer to parties. And given that, and other scholars who have said the same thing, I have this one curious one that says between a controversy, between 2 or more states, between a state and citizens of another state. Notice this doesn't tell me which one I should read, which paragraph I should read first, right? Although the first one it delineates this, but then in section 2 or paragraph 2, it then tells me that it refers to state. And so the Cherokee Nation, right, brought an argument against Georgia, and then Justice Marshall had to tell them, oh, you're supposed to read through number 2 through number 1, which refers to 2 states, and you're just not a state. Does this make some sense? All right, so I have, this is controversies between citizens of one state, correct, and another state. I take it, not their own. All right, so I have the first case. By the way, that provision was Madison and Henry loved it. They loved it. Not. They hated it. They argued against it. And you can imagine Patrick Henry arguing against something like that. Hamilton and Madison, those wonderful individuals, they both argued, I can accept this, but only if the state is the petitioner, only if the state is the plaintiff, never if the state is the defendant. And then last, Randolph and Pickering said, no one is above the law. We should accept it, truly. Chisholm versus Georgia is the first case. This is an individual who lent Georgia money on credit, and the credit amounted to, at that time, I don't know what this is actually worth today, but $70,000 to be paid, to be returned after the Revolutionary War is over. So after the Revolutionary War ends, Mr. Chisholm would like his money, and when he asked for the payment of the debt that is owed and acknowledged by Georgia, who is, or which is destitute, they don't have any money. They just say, we can't pay you, we're not going to. And so he then says, well, I'll see you in federal court. I thought there was something in Article 3, Section 2, Clause 1 that would allow me to do this. I'm going to sue you. And Georgia said, go ahead. Go ahead, come down here and sue us. And so in a district court, they did. And Georgia didn't even bother to show up. They didn't even defend themselves. What they did was suffer a default judgment. So that's the issuing court. Now I've got to get it, executed. So now I'm going to have to go down to Georgia and execute this judgment. And Georgia said, if you come down here and try and execute the judgment, the only execution will be of you. We will kill you, and we will not allow benefit of clergy, which doesn't mean, of course, that you can't have clergy people around. Whatever good they will do you. But you could do this. You could, if you had benefit of clergy, that meant that you were able to read a verse out of the Bible to show that you were literate. And then they wouldn't, implement the capital sentence. They would brand your thumbs so that the next time you didn't get to do this again, you only got one benefit of clergy. And why? Because they didn't want to kill people who were ecclesiastically trained. So they gave them a pardon, essentially, right? And so lots of criminals would then do what? They would always ask them to read the next verse, which is, I don't know anything about the Bible, although I did see the movie once. The next verse is Psalms 51. Am I pronouncing that correct? Right? 51. And they would memorize it. And then they would hold the Bible in front of them and then look as if they were reading it when in fact they were just singing along. Does that make some sense? All right, so what happens? Well, they don't go down, but now it has frightened the newly formed states that this is going to be a rambunctious sort of engagement where people are going to be suing states. So what they did was within a month, they got both houses pursuant to Article 5 to amend the Constitution. Within a year, they had ratified it. 2/3 of all the legislatures in the 13 states had now agreed to it. 2/3 of the legislators. That's Article 5, how to amend the Constitution. And then they amend it, and they put in the 11th Amendment. And the 11th Amendment says, although this is interesting, I thought, just how it's worded. Okay, by the way, when did it become activated? In 1798. Why? They did it in 1795. What took them so damn long? Well, they couldn't figure out whether or not there were other glitches, but the major one was they couldn't figure out whether the president had to sign the amendment. I'm not joking, that was a big problem for them. All right, so it says, the 11th Amendment says, and it says here, this amends the Constitution with regard to Article 3, Section 2, Clause 1. The judicial power of the United States shall not be construed. What the hell does that mean? Construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or by citizens or subjects of any foreign state. What the hell does that mean? What does construed do there? Why do they use the word construed? Who construes? I mean, the executive doesn't construe, do they? They enforce. And the legislature doesn't construe, do they? they posit law. Who construes? Courts, don't they? Construe the language, interpret the language. So maybe construe means something. Maybe that's important. And then what does it mean to have, you can't sue them in law or equity? What the hell is that? It will not extend to any suit in law or equity. What is law? What is equity? Law is a British common law, right? To get into a British common law court, you had to follow these narrow expanses of what constitutes a cause of action. And if you got just slightly out of it, you were fresh out of luck. You didn't get a hearing. So courts of equity arose, and those were ecclesiastical courts run by chancellors. And they engaged in, what, if you can't get a legal remedy, hell, you can get an equitable one. We can't give you monetary compensation, but we sure could give you an injunction. We could impose upon someone to do something or not do something. And so in the United States, there aren't two courts. There are just two kinds of remedies. You can get legal remedies, I sue in law, or I sue in equity. Or I do, and that's an inclusive or. I can do both. I want to sue you for money and I want you to stop doing what you were doing that caused me the injury in the first place. Does that sound, is any of this making sense?
Yes.
All right, so I have to remind myself that I'm being recorded. Otherwise, they'll use it against me and I'll get fired. But also notice, it's about, I can't get into a federal court, the judicial power of the United States, no federal court jurisdiction. And it's of citizens of another state. So I've got that diversity again, state, right, in the same sort of way that was permitted in Article 3, Section 2, Clause 1, correct? So tell me, what does this say? What does this prohibit? Seriously. Does that make some sense? I'm sorry.
Prohibit someone from suing the government?
Pardon?
Prohibit someone from suing the government or bringing the government to court?
Well, what was I mean, there are three theories that people have. The first one is this. What was the problem that created the 11th Amendment and is exemplified in its very language?
Like people from other states suing a
Yes.
different state.
Yeah, diversity. Someone from another state coming and suing a state. So is this totally saying just that? I mean, why put in from another state in there? Wasn't that the argument was correct? That this was an amendment to answer Chisholm, right? So is that what it's saying, that you cannot sue if you're from another state? And you can't get into a federal court? Could you get into a state court, you think? Remember, the federal courts are courts of limited jurisdiction, right? I only have a certain way to get in there, and that is federal question. It arises under the United States Constitution, federal statutes or treaties, or diversity. I'm not asking for the federal court to sit in their expertise. I'm asking the federal court to be a neutral forum, because John from Alabama is suing Mary from Mississippi. And God knows, you don't want to go to an Alabama court because they'll be biased towards John. And you want to go to a Mississippi court because they'll be prejudiced towards Mary. Right? So give me a neutral forum. Wow, how about I'll do it for you, a federal court, either in Alabama or Mississippi. Does that sound right?
Mm-hmm.
So I have that notion. Will this stop me from getting into a state court, which is a court of general jurisdiction? They can hear anything. They're not even strapped. They're not as strapped for justiciability, standing, mootness, ripeness. I mean, because the federal courts being courts of limited jurisdiction, they take those things very seriously. States take them much less seriously, and tribal courts just notice them. Well, does this make sense? The first question is it just an issue of diversity? But then if you just take it for what it says, the judicial power of the United States shall not be construed or extended to any suit in law of equity commenced or prosecuted against one of the United States by citizens of another state. Would that allow me, or would that stop me from getting in and suing a state that's just violated my constitutional rights? I'm not asking them to be a neutral forum because I'm upset about the way the defendant violated a state right and I need a neutral forum. Now I'm saying under subject matter jurisdiction, it fell under the Constitution, a federal statute, or a treaty, I want to sue this state. Am I allowed to, will I get myself in there now?
Yes.
As long as I'm from another state? Why is all that, what damage was being suffered by the people who wrote this amendment? Why does it have to be another state? Why do I have to be from another state if I'm claiming that Alabama, I can only do this if I'm from Mississippi or from another state outside of Alabama, that Alabama violated my constitutional rights? That sounds weird. I will hear you, but we're not going to hear. We're not going to hear this person. Doesn't that sound? So, I mean, if it means no suit, so long as you're from another state, no matter what the cause of action, that's another theory, right? Or that it's diversity. So I have diversity, you can't even get in. At least that satisfies plain meaning of some sort, correct? And what's the last one? Well, the last one is that because states are sovereign, they're saying this. And although it violates the canon, C-A-N-O-N, how a principle by which how you read statutes, how you read the Constitution, how you read contracts, is that if I'm going to make a distinction, right, then I'm also saying something about that which was excluded by the distinction. And so when I put in, when I said people from another state, I meant this doesn't apply to people from the same state. That's a canon, right? Canons are devices to help people understand. If I said, I want you to go out, I think I did this in one of the classes. I want you to go out and find robins, eagles, ravens, hawks, hummingbirds, wrens, and any other two-footed animal. Can you go out and find a human? How about a kangaroo? Could I? No. Why? I said any other. Well, because the canon says any general term that follows a series of specifics takes on the characteristics of those specifics. And if I said, here are some exceptions, and I only mentioned two, I'm telling you, not a third one. I didn't say it. Logic doesn't tell me that. But the canon tells you, well, yes, but you have to do this because this is the better way of reading this and getting someplace. Correct? However, the last theory is that it's sovereign immunity. You can't sue them, and I don't care this is why I said it's contrary to the canon. I don't care what state you're from. You can't sue a state. You just can't do it. How's that? Theories. I have it here, diversity 1332, and that's the purpose and the remedy. And that's what Mr. Boyd pointed out. And plain meaning, which is that no one can, irrespective of the cause of action, so long as you're from a different state. And then there's absolute immunity. Does anyone have absolute immunity? I mean, unless we already answered this question and say states do. But do any officers have absolute immunity?
Clarence Thomas.
Pardon?
Clarence Thomas.
and bad humor too. But absolute immunity actually is around, correct? Anyone who is a legislator in the performance of legislative duties is absolutely immune. You can't sue them. Anyone who is the executive for executive performances, you cannot sue them. For judicial judges, justices who are engaged in judicial duties, you cannot sue them. Interesting. This is even in a case in 1978 from Indiana. Stump, he's the judge, versus Sparkman. This is a case, I'm just telling you this because this one's hard to believe. Stump is a judge in this county, DeKalb County in Indiana. And he is approached by a woman who has a child, whose younger child she wants to have sterilized because her older sister was wild and got pregnant in high school.
We talked about this case in health law.
Yes, right, about justice. Did you all know it then?
I
didn't take
I
the
was the
class.
only one in the class.
Well, so she wants to have her daughter sterilized. Wow, she knows her daughter will be recalcitrant to this idea. And so she has a plan. Her plan is to go to the judge and get the judge to sign an order. In Indiana, in order for you to have this sterilization process performed, you have to have, number one, consent of the minor. Number two, you have to have a guardian ad litem to act as the advocate for the best interest of this child. Then you have to have an attorney who will act for the child's personal interest, right? You have to have all of that and a hearing. This judge just does this, signs it, after she says, I think my daughter is mentally retarded. She wasn't, she said it, and the judge signed an order, right? How did she get her daughter to go to work? She told her daughter, this must be about parental influence. You're having an appendicitis. You have an appendicitis, and you need your appendix removed. An appendectomy is called for. And she said, Mom, I feel fine. You're feeling pain. It's odd that I know the logic of that term is that you cannot have an unfelt pain. You can have an unfelt injury. But nevertheless, she persuades her daughter that she needs an appendectomy, and the daughter complies. And she goes in and has this. The doctors all comply because it's a court order. And then she has her tubes tied, comes out. And then she eventually gets married. And she becomes Mrs. Sparkman. And then as Mrs. Sparkman, she and her husband would love to have issue, which is the law's charitable way of talking about children. And she cannot do it. So after millions of times of joyful trying, there's a failure. They finally go to a doctor, and the doctor says, you're sterile. Have you heard about this? No, I had no idea. Well, your tubes were tied. They were done surgically. God, really? So she sues, not her mother, but she sues the doctor and the hospital. Well, the hospital has a great defense, right? We're under a court order. What the hell are we supposed to second guess a judge? And so that they get dismissed. And then what about the judge? Although the judge acted not as a judge when he signed that, it was under the color of the law of being a judge, right? And it was illegal. It was against the law. Nevertheless, the Supreme Court said he acted in the performance of judicial duties. He is absolutely immune. How about executives? How about the enforcing part of the executive branch, like police officers? If I put a police officer on the stand, could they lie and escape civil liability? Yeah, they're absolutely immune. You could prosecute them for perjury, but they're absolutely immune. You can't sue them because of the chilling effect that this would have on police officers. And what about prosecutors in their prosecutorial role? Yes, you cannot sue them. You might get them disbarred and fired, but you cannot sue them. And great cases, Imbrigo, 1976, he knowingly used perjured testimony. Does this all make some sense? So there is absolute immunity. There's also qualified immunity for police officers, and that is, given the law, would a reasonable person in this officer's position have known that he or she was now violating someone's rights? Are they on notice? Do they have? if they're incompetent or willfully violating people's rights, then they're not covered, but otherwise they're covered. And it is like absolute immunity, it is immunity from suit. So the minute you raise it, which you would raise it immediately, irrespective, correct? And then if you are denied immunity, then you get to appeal it immediately because it's immunity from being sued, not just from damages. How are we doing? Are we all right? Yes, ma'am.
What about like legislative staff or executive staff? Would they have that, the absolute immunity?
No.
Okay.
No, but it depends on how close, how is, because of the arm, the agency principle notion, how
Gotcha.
close is that? But they don't always have it, I should say. In fact, they have it rarely. But it's whether or not they were. How would you figure this out, actually? You would figure out whether or not they were acting totally and completely within the scope of their authority.
Gotcha.
And if they are, then there's a good argument for absolute immunity for them as well. But if they're outside of it, and what are they going to be charged? What are they going to be argued about when it happens that way? I didn't authorize you to do that.
Mhm.
Right? So then it would clearly not be, and it wouldn't, and you couldn't go after the principal. If you can't go after the principal in this case, you couldn't go after the agent in this case. Does that make some sense?
It does, yes, thank you.
Are we all right?
Yeah.
Are you sure? Okay, so the next case to try and figure out the theories of diversity, plain meaning, and absolute immunity is Hans. This is a case that clearly, 1890, this is a reconstruction case in which Louisiana took out a bond and to further, bonds would come to maturity and then they'd have to be paid off in order to facilitate construction. And when they came to maturity, they weren't paid, and people argued that you've altered this by fooling around with the contracts clause. The contracts clause only refers to states interfering with pre-existing contracts. So here was a pre-existing contract. You give us this money now, and this money will be what? This money will be returned to you, and I'll use it for these constructions, this kind of engagement under a Civil War construction contract. Does this make sense? So now they're arguing that the state of Louisiana has actually violated Article 1, Section 10, Clause 1. Article 1, Section 10, Section 10, I think. Where is it? Section 10, no state shall enter into any treaty, alliance, or confederation, grant letters of marque and reprisal, coin money, emit bills of credit, make make anything but gold and silver coin a tender of payment for debts past, any bill of attainder, ex post facto law, or law impairing the obligations of contracts or grant titles of nobility. So it's that second to the last clause, obligations under contract. And who was this person? Someone who bought the bills, who engaged in the purchase of those bonds, right? Then those would probably be Louisiana people, you think? I mean, people from another state are not going to buy bonds for Louisiana. I guess they could, but this person, Hans, was a Louisiana resident. And so now he is accusing his state. So it's an in-state person suing the state. So I'm out of the first two, am I not? This isn't diversity. And it's not plain meaning because although I'm referencing the Constitution, I'm in state. So this isn't the 11th Amendment. Not by the plain meaning of the 11th Amendment or the plain wording. Am I right about this? Well, the court said, you're still not going to sue your state. You're not going to sue your state because States are sovereign. In fact, the meaning of the 11th Amendment is based on the notion that states are sovereign. That is sovereignty that came over from Great Britain. You cannot sue the king without the king's permission. That is what informs the 11th Amendment. You can't do it. And here you were, right, thinking that the bedrock of American law is the Constitution, when in fact it's British common law, which, if you think about the paradox of that, statutes are meant to amend common law. The basis for passing statutes is the Constitution. And here is the common law amending what we have a presupposition about, the superiority of the Constitution. In fact, there's a clause, right? Are we all right with this? All right, so in Hans versus Louisiana, it is the vindication is of absolute immunity. The states cannot be sued at all. I was going to go into Seminole, but I now think that I should wait until I get through with Ex parte Young, if you don't mind. I have another one though. An Alden versus Maine, this would answer the other question. In Alden versus Maine, this is a correctional officer in the state of Maine who is not being paid pursuant to the Fair Labor Standards Act. He has worked overtime and he is due, by virtue of that, a certain amount of money, and he's not getting it. And so, like a class action suit, he brings a suit in which people can join, and he brings this in a Maine court, federal issue in a Maine court, and he's a citizen of Maine. And the court said, have you not read sovereign immunity? We meant that seriously. You can be in the state and you can bring a suit even on a federal issue, clearly a federal issue, and you're not going to bring this in even a state court. They're sovereign. If they don't want to do it, then they can shut you out. Does that make sense to you? Does that seem to make sense? Okay. Seriously, does this seem clear or even correct to you? Does it seem convoluted a little bit, but it's not even near convoluted yet? Next, I want to do, as I said, I wanted to do Seminole Tribe, but I should wait for, so how can I get around the 11th Amendment? I thought, well, all right, so right now it looks like you can't pass the doors of the courthouse if you're going to sue the state. Because unless they let you. So I think you get around it this way. Could I get a state to waive their right not to be sued? Sure, I could do it. And I'll show you at the end, I'll show you a wild case in which a state did. And it's the same state that is mentioned here. Alabama, and this is Bell South. Alabama agreed to entertain a suit against the state of Alabama in an Alabama court. Right? And who won? Do you need to read the case? It's a wild guess, but Alabama won. All right? And Bell South said, well, then I'll appeal. But this time I'm going to appeal in a federal court. And not only the petitioner, but Alabama said, you can't. You can't. And they said, wait a minute. The 11th Amendment said I can't bring what? Under original jurisdiction, I can't bring a suit in a federal court. But how about a review? This isn't original jurisdiction. This is appellate jurisdiction. I'm not suing you anymore. I'm having a suit reviewed in a federal court. The United States Supreme Court said, good advocacy. That's what you should have argued. And you're right. You're right. If you waive it once, you've lost it. Does that sound interesting? All right, so you can do this, although it's unlikely that they will. So then what about the next one? Any government could sue a state. Can the United States sue a state? Sure. Can another state sue a state? Sure. Right? Can a tribe sue a state? No. No. In fact, one of the avenues that we'll talk about, you can't even bring the avenue suit in a state court, in a tribal court. Are we all right with that? So I have that. How about a political subdivision? Can I sue Auburn? Auburn's a political subdivision. Could I sue Monroe County? Could I sue Wetumpka for misappropriation of a tribal name? Or whatever the hell that is. I mean, yes, the 11th Amendment refers to states, not political subdivisions of the state. Any arm of the state, a political subdivision is a political subdivision of the state, but it is suable. It is suable. We'll see in what ways it's suable in a strange way. You can hold it civilly liable, but you have to hold it civilly liable not vicariously but directly. You cannot sue a political subdivision on the grounds that it is vicariously liable for its agents. This is the other part, not the immunity running one way, most of the time. It's whether or not the suit could try to do it, and the state could consent to it. But if the state didn't, then you can only sue the state if the state itself is directly negligent. Does everyone understand the difference? Directly. Great. So I have I could have the political subdivision, and the only way to get around that is I gave you an example. McMillan versus Monroe County. This was Alabama, and Monroe County, when it was sued, said, we're really a subdivision, but all we do is implement state law. And that's all we do. I don't know if that's true or accurate, but that's exactly what they argued, and the Supreme Court said. Then you have sovereign immunity because you're just a literal arm of the state. If you were implementing your own law, county law, that was independent, which now, Alabama doesn't have it has no home rule law. Everything has to be through the state legislature. So there's an argument that perhaps all of them could get away with that. I don't know. I'm sure that won't work, though. Are we all right to this? Anyone confused? Seriously. Okay. Do you all know about this beforehand? Did you all worry about the 11th Amendment beforehand?
I wouldn't say I'm particularly worried about it necessarily, but I knew what sovereign immunity was.
Okay.
Worry about it every night.
All right. So
Keeps me up at night.
Just let me know when it starts to get, if it gets too boring. And the most profitable way to do this, though, is Ex parte Young in 1908. And the thing to remember is the difference between a tautology, an empirical statement, and a self-contradiction. All right, so a tautology is a necessary truth. This is didactic, it's not part of the case. Part of it will be the case, part of the case, but a tautology is a statement that is necessarily true. 2 and 2 is 4. Necessarily true. It doesn't matter how many times I try it, and if I ever came up with a different answer, it's wrong. Correct? So it's necessarily true. An empirical statement is true or false, depending on how the world looks. Right? I can go out and verify it or falsify it. So I could say bachelors or unmarried males past the age of puberty. That's a tautology. And bachelors are happy. That's an empirical statement. Sure, in that other room they were happy. What about in the next room? I could ask. Bachelors or unmarried males past the age of puberty. Sure, they are in this room, but what about the next room? But that would be a ludicrous, remark. Right? And then there are denials of tautologies where clearly always false. I don't have to go and check. They're always false. Bachelors have wives. 2 and 2 is 5. Bodies are not extended. I have a pain I cannot feel. Does that make some sense? So notice that if you see that tautologies are different from empirical statements. Empirical statements, tautologies tell me how to use a word. Empirical statements tell me about the world, and contradictions, self-contradictions tell me how not to use a word. So a big mosquito flies in here, not being from Alabama or from the South. This thing, this proboscis pierces my epithelium tissue, and we see blood coming out, and then the anticoagulant getting secreted in there, and then I feed it with more blood, and finally it's full and bats off, flies away. and you look at me and say, Cliff, don't scratch that. And I said, scratch it. What does scratching have to do with mosquito bites? What would you say?
I tell you you're not supposed to scratch it. I'd probably,
They told me not to scratch it. And I
I'd
said,
probably
"Why
give you
would I?"
a motion of what, of maybe what scratching.
No, I didn't ask what it is. I just said, what does it have to do with mosquito bites?
Mosquito bites turn itchy.
Yeah, pardon?
Mosquito bites turn itchy.
Yes. What if you then, yeah, so that's an empirical remark, right? What if I then said itchy? What does itchy have to do with scratching?
You scratch when you get itchy.
Scratching
Did you
itch.
notice that? Is that something you noticed in the world? What would it be like if I said, God, I have one hell of an itch. Thank God I have no inclination to scratch it at all. That's a tautological relationship. Itching, to have itch, it means I have at least an inclination to scratch, correct? Right? Does that mean but my head is splitting. Thank God I don't feel it. I can have never an injury I can't feel, but I can not have a pain I can't feel. Does that make sense? All right, so this is a tautology. What happens in Ex parte Young? In Ex parte Young, this is Minnesota is, you don't forget that when railroads were coming through, and this is the railroad, Ex parte Young deals with a railroad through Minnesota. And what do railroads do? Well, they take public possession of Minnesota land on both sides of the track, and then they have a monopoly through Minnesota. And so they're price gouging. And so poor Minnesotans are, taken to the cleaners every time they get on a train running through Minnesota that what was there by virtue of Minnesota being forced to give up its land for the railroad. Right? And then they get gouged when they put on cattle or whatever the hell they have in Minnesota, snow, and they ship it someplace, right? And those are the things that they were upset about. So the Minnesota legislature says the following, we're putting a cap on what you can charge. Railroad, you took land from us and now you're gouging our people. You're not going to do that anymore. We have a cap for you. And the cap is, whatever the cap is, if you violate it though, if you violate this cap, it's a felony. You could spend 5 years in prison and you will suffer for every count $2,500 fine. This is 1908. Good grief. What is a dollar worth in 1908? I mean, people were making $40 a month? $2,500, right, for every act. And so because of justiciability, Minnesota has levied this, and the railroads in Minnesota, they're scared, are they not? I don't really want to violate the law because some horrible draconian thing could happen to me. But look at all this money I'm wasting. I'm missing, right? If I curtail my charges to the mandates of that statute. I need something. I need to get into court and have this adjudicated. But this is a federal court I want to go into because I'm claiming Article 1, Section 8, Clause 3, the Commerce Clause. You're interfering with interstate commerce, damn it, with this cap on fees. I want to go to a federal court. I don't want a state court to deal with this. Besides that, it'd be a Minnesota state court. What kind of a fair deal will I get there? Makes sense? All right, so I want to get into a federal court, but they haven't charged me yet. And they haven't put anyone in prison yet. Well, they might if I do this, and I will, if I don't, I'll lose all this money. Can I get into a federal court under these conditions? Remember, to get into federal court, I have to have standing, which means I have suffered an injury, a concrete, particularized injury, right? And it is it is causally related to a statute in this case, right? And that the court could give me a remedy, right? And it has to be a live one. The game is afoot, as it were. It is not pending, it's not just possible, and it's not moot. It hasn't already occurred. Can I get into a federal court? It's not a political question either. The courts said, well, we have this pre-enforcement review. We'd have to do that for people who would otherwise suffer a massive hardship, loss of whopping money or put people in jail. I mean, they're going to lose one way, win or lose one way or another. So that, and the issue is fit, which means that it's mostly a legal issue, not an empirically detailed, factual, intensive issue. It's fit, it's mostly legal. And so we'll give this to you. What do you want? You want a declaratory action. Tell me my rights, right, that are guaranteed under Article 1, Section 8, Clause 3, and by virtue of you having hegemony with that issue, Congress. And I want an injunction if my rights favor me. So I want a declaratory action and an injunction. Stop the state. So when they get this declaratory action, the Attorney General, Young, says, screw off. I'm not going to, I'm just going to bring this in a state court. Make sense? So they bring it in a state court. And the railroad says, we're going to sue the state of Minnesota now. We're going to sue this officer. We're going to sue the officer. Sue the state, sue the officer in a federal court. Again, are we all right with this? Does this make sense?
Mm-hmm.
Seriously? All right. So now, the United States Supreme Court says, in Ex parte Young, what you should try and do, and I think I have it here, don't I? Strip. What you could do is think of it this way. There is state officials, and they can do whatever the state allows them to do. That's their official capacity to do this. If they get outside of that capacity, they're on their own. They're what is called ultra vires. They're beyond the scope of their authority. And because of the supremacy of the Constitution, the supremacy clause, in fact, it is impossible, not an empirical impossible, a logical impossibility that a state could violate the Constitution. Are we all right with that? In other words, whatever the state does, it has to be constitutional because it has to conform its laws to the laws of the Constitution. If it looks like it's not, then it's not the state actor acting within the scope of his or her authority. They're acting outside of it. Does this sound like doesn't this starting to sound to you like, I'm sure you've had this experience where you lied and you were on the verge of getting caught, and now you have to lie again and again and make another story twist over here to make it. All right, doesn't this sound like that? So now I can sue, not the state, and it almost looks like I couldn't possibly sue the state, but now it's moved from, we're just not going to open the door to you, that now it's a logical impossibility. But you can sue the officer, Young. Sue Young. Don't sue me, says Minnesota. Sue Young. You can sue Young in two different ways. You could sue Young in Young's official capacity for prospective relief. Does that make sense? That is, because he acted under the color of the office of Attorney General, you can sue him to stop him, assuming he continues in office, stop him from acting under the color of the Attorney General's office and doing things that would otherwise be what? Wild extravagances beyond the scope of the state's fidelity to the Constitution. Does that sound reasonable? And because you may have suffered some damages, you could sue him retrospectively, but now you'll sue him in his personal capacity. Prospective damages, official capacity, retrospective for legal remedies. Equitable tomorrow, legal today or yesterday. You can sue him in both ways, but you have to keep them separate. You can strip him of his office and sue him individually, and then sue him prospectively to have the office stop doing what it was never entitled to do. And by the way, if it is something that he wouldn't have known about, then he might enjoy qualified immunity. If he couldn't have figured that out on his own. Notwithstanding, he's the Attorney General, I assume he went to law school, some idea about these sorts of things. Does that make sense to you? Are you sure? Okay. I can tell you I'm having a blast, but then I'm doing all the talking. All right, so here is, let me go back up to the Seminole tribe. Of course, now you'll see why I wanted to move it, because what happens here is two things. In Ex parte Young, they said you could strip the person unless the statute provided what is called a detailed remedial scheme. Did the statute that was supposed to be violated, did it already tell you how to deal with it? If that happens, then you can't strip. All right, so here's the Indian Gaming Regulatory Act. Gaming in the United States by tribal nations that are federally recognized is a step process by which they have to demonstrate what kind of gaming they're involved in. And if they do that, if it's gaming one, which is usually skill or nominal prizes, bingo or something, real bingo, then those kinds of games are within the exclusive jurisdiction of a tribe. Makes sense. Gaming two is those kinds of games that are just not exactly, Atlantic City or Reno or Las Vegas gaming. And Article 3, and then they have to get an intertribal conference agreement, make sure that the state has allowed that sort of gaming before, and then you can get Gaming 3, which is full-blown, Vegas gaming. Just to be right, but the full-blown has to be negotiated in what they call a compact. And the compact has to be between the tribe and the state. If the tribe wants to do that, the state must negotiate with them. Remembering that gaming, 68% of all gaming employees are non-natives. Right? It brings this wealth to communities. The Mohegans, in Connecticut who have been literally, pro-British, pro-American, whoever was, the host culture. Mohegans in Connecticut, just a wealthy tribe. Other tribes are starving or dying or whatever, but not the Mohegans. Anyway, but the Seminole Nation wants to do this in Florida, and they ask for a compact. Lawton Childs was the governor at the time, said, I'm not going to negotiate with you. If the state does not want to negotiate with you, the court said, the Indian Gaming Regulatory Act says, you can bring that state into a federal court and sue it. All right? So that's what they try to do. And what does the United States Supreme Court say? It says, there's a problem. Remember, we have this thing called sovereign immunity. I grant you, now I catch on why construal meant so much, because this was a congressional statute. This wasn't a court saying that they could sue. This is the United States Congress passing a statute, right, that says the tribe can sue a state in a federal court. Correct. Does that make some sense? Right. They said they could do this. They could bring this case this way. So what do I need to do? You also stripped Lawton Childs and wanted to sue Lawton Childs in his private capacity and in his professional capacity. You're suing Florida and Lawton Childs. Well, I can tell you now, you cannot sue Florida. The 11th Amendment, I think the hierarchy is when a statute, which the Indian Gaming Regulatory Act is a statute, and it confronts the Constitution, who wins? The Constitution, doesn't it? So the Constitution prevails over that. And can you sue Lawton Childs? No. Why? Because they gave you a detailed remedial scheme. What was the detailed remedial scheme? Oddly enough, Rehnquist wrote this. What was the detailed remedial scheme? Let me see if memory serves. Said if they will negotiate, but only in bad faith, or they won't negotiate at all, you can sue them in federal court. So I could sue them. I could strip them. I could strip Lawton Childs with an image, and I could sue him, Lawton Childs, in federal court. But I can't, and I can't because there's a detailed remedial scheme, and the detailed remedial scheme said, what? Sue the state in federal court. But I can't do that because of the 11th Amendment. So do I not have a catch-22? The catch-22 that was original was Hussein, who was flying bombers over North Africa in World War II. The mortality rate is shocking. It's like in the 70s, 70%, right? And so he says, I don't want to fly anymore to his commander. The commander says, well, you don't have to fly anymore if you can just prove two things. One, you're incompetent, and you're incompetent, you're mentally incompetent, and you also request not to fly. And he says, all right, well then I think I'm competent and I don't want to fly. He said, fine, you're on the detail for tomorrow. Why? He says, because, well, if you ask not to fly, because only an incompetent person would want to continue flying. So if you ask not to fly, you're not incompetent. And so long as you only fly and never ask, you didn't ask. So you have to always fly. You're caught in a catch-22. That's what happens here. I cannot strip Lawton and get my remedy, but I can't just go off and bring the suit against the state of Florida because of sovereign immunity. Ain't that cool? All right, so but something else happens from this. Something that comes from this. And that is a case called, you don't have to, I'm not saying you don't have to, there's no testing questions on it. It is from this Seminole tribe. There is also, the next big case is the city of Morney, which is in 1997, but I have to go through something for that. May I? I have 25 minutes. Could I? Yeah. May I? All right. So in this case, the religious freedom was tested under Sherbert versus Werner, and that was 1963. And in 1963, in order to violate free exercise,
I'm in con law, so I'm reading about that one right now because
okay.
we're going over this
Okay,
brief.
so
Yeah.
correct me when I'm wrong. In this case, in order to, what the petitioner would have, the plaintiff would have to demonstrate is that the state has put there is a substantial burden on their practice of religion. And then once that is done, the state has to show or satisfy what is called strict scrutiny. They have to show they have a compelling interest, and this is a narrowly tailored way of achieving that compelling interest, which means they're perforced to do it, right? So that was from 1963 until the Employment Division of Oregon versus Smith. And that's when, by the way, what's really weird about that is that Sherbert versus Werner was written by Brennan. Justice Brennan, at the time especially, and today, really outrageously to the left. Right? And then Scalia writes the Employment Division of Oregon versus Smith. And you think that these were, they should have been just me. So anyway, in division of, pardon?
I get.
So in this is that these are two Navajos who belong to the Native American church. This is a church that I think everyone would like to belong to. It's peyote every Saturday afternoon. I'm not joking. I have tried to get into that church. The Native American church has two individuals who are practitioners. And they're working in Oregon, and they're and oddly enough, they're in a drug rehab program. They're counselors. So one day it occurs to them, hey, I don't know if we've asked those two gentlemen whether or not they take drugs. So they went to them and said, do you take drugs? And they said, oh, no, religiously. We take it for religion. I mean, we're every Saturday night because we're communicating with the great Wankan, right? And so the argument was, no, that's a god. That really is a god. But for the wrong group, it's for Algonquins. Anyway, so he brings up that he is. So they fire him. They fire the two of them, right, for cause. And so you're interfering with my right of practicing my religion, correct? You can't do that. You cannot interfere. So come up with your compelling state interest. What one would you possibly have? And that's when it went to Scalia at the Supreme Court, and Scalia said, no, we're overruling Sugar. What actually the test is there a neutral law of general applicability that there is, and your religion bounces up against it and gets burdened? Well, too bad. As long as so if I said this, if the statute said, you cannot modify a military uniform. That's a general rule, a neutral rule of a general applicability. And now you want to wear a yarmulke well, you know what? You're going to lose that. But if the statute had said you can't wear a yarmulke, now you can win, right? Because now it is not a neutral law; it's a very specific. Does that make some sense? Now you're back to Sugar. Are we all right with this? Well, what did everyone do when Scalia did this? What happens to your First Amendment free exercise? It doesn't look anything like what it once looked like, correct? So Congress passed the Religious Freedom and Restoration Act, which said Sugar is right and Smith is wrong. But of course, they can't override United States Supreme Court precedent, right? So that ruling, it's just right. So now we go to the city of Bernie, and here a church wants to add, because it wants more practitioners, it wants to add. I know this sounds, I'm so callous. That it wants to add an addition to the church, but the city says you can't because you're a historic landmark. So they said, well, you're interfering with our religion, right? And we're bringing a suit, but we're not bringing a suit under the free exercise. We're bringing it under the Religious Freedom and Exercise Act. And the United States Supreme Court said, well, really, you cannot take that law and use it like you're incorporating, right? You cannot do that. You can pass a law pursuant to the 14th Amendment, Section 5, necessary and proper clause, but you cannot incorporate this because it is what? Stronger than the constitutional provision of free exercise, which is neutral law, right, of general applicability. Or is there something happening to them? Are they people storming the Bastille?
They must have had like a study session.
Yeah, I think they.
Yeah.
So does that make sense? Right? And the reason for this is that the city of Bernie, you couldn't do that part. You couldn't bring it down and do that. So in this case, that's when they found it was unconstitutional. And when they found that it was unconstitutional, that is, that trying to use it, that's when states pick them up. Alabama has its own Alabama Religious Freedom and Restoration Act, right? They can do it, but you cannot do it with the courts. I mean, the federal court can't do it. Bring it through like it's incorporating something. Right? Does that make some sense? You sure? All right, so I have that. And why did I bring that up? Where did this come from? Well, how did I stop? Why did that act get stopped before at Seminole Tribe, the Indian Gaming Regulatory Act? Why did it? Because of isn't this the case? I passed a law, but I passed a law that was pursuant to a statute. What was it? Article 1, Section 8, Clause 3, the Commerce Clause. Right? But Article 1, Section 8, Clause 3 comes before the 11th Amendment. When the 11th Amendment was passed, it modified everything that came before it. So if you want to pass a law, right, if you want to pass a law that will allow you to sue a state, you have to pass it on the principle of a constitutional provision that came afterwards. The 14th Amendment, Section 5, will do that for you. Make sense? You can't do it beforehand because it's all been modified already. It's all been addressed by the 11th Amendment. Hence, why they thought they could do this with the Religious Freedom and Restoration Act, because it was passed by the 14th Amendment, Section 5. All right, but they can't. We'll be all right with that. So try a few more. And this is what it has to be also, because this is the proportionate and congruent test. So I can pass it by the 14th Amendment, Section 5, but it has to be coextensive with the constitutional benefit, okay? Are we all right with that? If it expands it, it goes beyond it, 407. Subsequent remedial measures, if someone gets injured on my property and I go out and fix it, right? Can they use that I fixed it to sue me for negligence? No. Not in a court. It'll be disallowed because that would stop me from ever fixing it. So John falls down and hurts himself. Mary comes along, falls down, hurts himself. Tom falls down and hurts himself. Right? I got my pronouns wrong here, but does this make some sense? Are you sure? So we don't want to let that Good Samaritan Act perhaps work to the person who has the ability to do this, change this. And that's one of the reasons here, right? I want to embellish this right because the Constitution with the Bill of Rights is just a floor. It's not a ceiling. I can always give you more rights than the Constitution gives you. I just can't give you fewer or less, right? So in this case, I want to give on religion grounds, Religious Freedom and Restoration Act. But I cannot incorporate that or have that apply to the states and have it worked against the states unless it is coextensive with the Constitution, not with the act itself. Are we all right? Okay, so I have 3 cases. There are Kemmel versus Florida, the Florida Board of Regents. This is a 2000 case. All right, I have 15 minutes or 16. If you will, just imagine, I was hired here when Auburn was still Alabama Polytech. No, not really, but yes, I was hired here a billion years ago. And the salaries that I got then were wonderful, but they were nothing compared to salaries that people get today. Nothing, right? Eventually, my incremental increases by not getting fired, right, will just what? They won't add up to someone who comes in eventually at this level. They'll come in from, Princeton or Yale, and I came in from some, cow dung university. And this individual is going to be paid wonderful salaries, and they'll take their incremental increases the longer they stay here. Does that make sense? And get promoted. Does that make sense? My salary is going to get compressed. And I don't think that's right. It's ageism. Ain't it? All right? And that's what these people did. These were all professors at the Florida universities, and they brought a claim saying that if you don't make adjustments here, I'm going to get salary compressed. Right? These junior faculty members are making more than I am. And that's not fair. Right? So they brought a case, and they brought it under the Age Discrimination Employment Act. Okay, and what did it say? The state can do this, and they can pass intermediate scrutiny. They have an important state interest, and this is targeted for that. It's neither over-inclusive nor under-inclusive. Does that sound unreasonable? Right? But what does the Constitution guarantee just against discrimination for the aged? Rational scrutiny. Rational, that is, are you discriminating against an old person because in a way that is illegal, unreasonable, right? So in other words, the Constitution guarantees non-discriminatory behavior at a much lower rate than does the Age Discrimination in Employment Act. So that's higher. That's not proportionate nor congruent. So I can't use it. I can only use what the Constitution would afford me. Does that make sense? All right, so I have, are you sure? Take the second one, University of Alabama versus Garrett. She's a head nurse at the University of Alabama, Birmingham, and she is horribly diagnosed with breast cancer. She takes a leave of absence. She's a head nurse in a department. She takes time off. She has a double mastectomy, and she has radiation, and she has chemotherapy. Finally, she goes into remission. And where does she want to spend her likely last 5 years of life? Back at UAB. And what does UAB so charitably respond? No, we don't have a position for you. Sorry. And she says, well, I'm going to sue you on ADA. You're not making a reasonable accommodation. Can she do it? Well, is that proportionate to what the Constitution guarantees for individuals who have any kind of physical mishap? No, they are. The ADA gives you intermediate scrutiny again, and the Constitution will only give you rational scrutiny. In fact, if given that the employer pays for health care for the employee, which can include the family, your family can have problems that will kill by the health insurance. Why wouldn't I want to discriminate against you? I mean, it's reasonable to do it. Does that make sense? It's heartless, but it's reasonable. I mean, economically. Are you right? Last one. No, almost last one. The Department of Resources versus HIB. This is the Family Medical Leave Act. And that was to stop gender discrimination. And gender discrimination is protected at intermediate scrutiny. Fortunately, so is the FMLA Act. It is also protected at intermediate scrutiny, so you could sue on this. Make sense? Right, last one. This is where the state of Alabama, I just think it's funny. The state of Alabama in Johnson versus Sorensen, I don't have it down there. This is a Alabama 2005 case. There is a football team in Alabama, although it's quickly leaving someplace, I guess. Right, and the Alabama football team it hired a man named as the head coach, Mike DuBose. Have you ever heard of this guy? I haven't either. But Mike DuBose is the head coach. I don't think he lasted very long. But what does he do? He hires Mr. Johnson as an assistant coach. And under their contract, Alabama says, you can stay here as long as DuBose does, unless DuBose complains about you. You can stay here, but your contract is always at will. But if we fire you without cause, we'll buy your contract out. Sort of like what Auburn does all the time. Here's $15 million for the last football.
Because we can't pick a good football coach ever.
Even
Yeah.
Dave Leach, the past president, they paid him off. And why did they pay him off? Because they were frightened, believe it or not. They said they were frightened that he would come back and take advantage of tenure. And that you'd never get rid of this anal orifice. Wow. Anyway, so this is, God, I gotta stop talking this way.
You're good.
So he says out, buy out, right? So DuBose gets fired and they let Johnson go. Johnson says, goes out and finds, trying to do the proper thing. He goes out and gets a job at the Citadel. But they don't pay like Alabama. I mean, who does? But Citadel then pays him. And he goes back to Alabama and says, I'm not asking you to buy me out. Could you just make up the difference for a year? And Alabama says no. And he says, well, if you're going to be, anal orifices about this, I'm going to sue you. And so he does. He sues them. And he wants to sue them. And he says, well, I'll take a state court. Hell. And they say, fine, you'll go to a state court. He goes to a state court. He's suing the state of Alabama because University of Alabama is a function of Alabama, just as Auburn is. we all right with this? She goes there, and they said, you know what, you should have paid attention. I know you're a novice, but you should have paid attention. What? You had this, they had a contract provision in it, right? But there's nowhere in this contract where it says it waives sovereign immunity. Did you know about sovereign immunity? We're not responsible if you make a contract and you don't understand sovereign immunity. I'm afraid sovereign immunity is going to stop your claim. This is how the Supreme Court ended it. Petitioner has learned a valuable lesson. He has been taught the hard way that the rigors of a contact sport like football pales in comparison to the roughness of Alabama contract law. Is that not breathtaking? Well, I hope this was not enlightening, but at least not too baffling, not too bizarre, although bizarre it is. Oh, no. You silly people. May I do anything else for you? Anything at all that you need?
You ever have any questions?
Any questions?
I learned a lot about the 11th Amendment, though.
Yeah, just what you didn't want to know. Are you sure? Okay, well, thanks for inviting me. I enjoyed talking, and of course, that's my. This is where I don't have dates actually. But thanks so much for inviting me. It was fun, and thank you, Mr. Boyd.
You can stop calling me Mr. Boyd, Dr. Perry.
Well, thank you for inviting me.
Would you like to come back eventually? Talk about
Yeah,
this?
would you like to
Yes.
come back again?
Yes, of course. Anytime you want me, I'd love to be.
Sweet.
I'd love to. Thank you all. Have a great weekend.
Thank
See you
you
later,
for
Dr.
coming.
No, this is only Monday. Have a great weekend.
See you as well.
See tomorrow.
What a man.
For real.
What a man.
I love him.
I know.
That's why, like, I really hate, like, not going to his classes, but, like, it's so
easy to
hard. And, like, I only have that one,
And then
like,
on
it's my
Tuesdays.
only class on Tuesdays and
And they're on
Thursdays.
Tuesdays.
So I'm like, but I feel so bad because I love him and I love going to the class and he's
I
so
was talking
funny.
to somebody today and they were like, are there any good professors like